I would like to start with my presentation with saying that I'm very grateful to be a part of this very important project for the whole Central Europe and to be part of this conference today. I'm going to speak about marriage and partnership in Serbian family law. And first, I will start with constitutional provisions about marriage and partnership, which says everyone shall have the right to decide freely or entering or dissolving a marriage. Marriage shall be entered into based on the free consent of man and woman before the state body. Non-marital cohabitation shall be equal with marriage in accordance with the law. So this is Article 62 from the Constitution of the Republic of Serbia 2006. And what about marriage? I'm giving some statistical data. Today in Serbia, marriage rate is about 5 in 1,000 population. It decreased from 75 30 years ago. Today, approximately every third marriage ends in divorce in comparison to every 7 30 years ago. The marital structure of urban and rural settlements is different because in rural we have patriarchal model of the family. Percentage of divorces almost double in urban settlements. In 2011, the population growth rate was minus 5.2 promiles. In 2020 was minus 7.7 promiles. The birth rate was in 2019 9.2 and in 2020 8.9. Mortality rate was in 2019 14.6 and in 2020 16.6. So it should probably be due to COVID-19 illness. Today in Serbia, Serbian Family Act 2005 is in effect. The form of solemnization of marriage is obligatory civil marriage. Marriage concluded in religious form does not have legal consequences. However, nowadays, a significant number of marriages are concluded in religious form apart the civil ceremony. Family Act regulates 2 causes for divorce: divorce by mutual consent and disturbance of marriage relations or objective impossibility to achieve cohabitation between the spouses. The Family Act 2005 has introduced the mediation during divorce proceedings. It consists of 2 phases: reconciliation and settlement. The aim of reconciliation is to resolve disturbed relationship between the spouses without conflict and without divorce. The aim of settlement is to resolve disturbed relationship between the spouses without the conflict after divorce. Settlement on parental rights and property. Statutory property regime in marriage is the community property regime. The community property is the property the spouse acquires through work if they live together. The property that the spouse acquires before marriage remains his or her separate property. Property that the spouse acquires during marriage by inheritance, gifts, or by division of community property becomes his or her separate property. The prenuptial or nuptial contract is introduced in Serbian law by Family Act 2005. The authority for issuing of the prenuptial contract now belongs to the notary public, as this is according to the law of notary public from 2018. Another effect of the divorce is habitatio. Habitatio is the right of a child and a parent exercising parental rights to live in an apartment owned by the other parent. The condition for acquiring habitatio is the child and the parent exercising parental rights do not have property rights to to an unoccupied apartment. The right to residence lasts until the child acquires maturity. The child and the parent do not have the right to residence if the acceptance of their request for the right to residence would present manifest injustice for the other parent. So here we have a subjective element to the right to habitatio. Another effect is right to maintenance. A spouse who lacks sufficient means of support, who is unable to work or is unemployed, but without his or her fault, has the right to maintenance. This is about two cumulative conditions, except the second condition consists of two alternative components. These conditions are of objective nature, you may say. Although the fault as a category is abundant in the family law, the right to maintenance is not quite objective, because the spouse can lose the right to maintenance if the acceptance of his or her request for maintenance would represent manifest injustice for the other spouse. Another form of family relationship or the relationship between partners is non-marital cohabitation. Non-marital cohabitation is the sustained cohabitation of a man and a woman between whom there are no marriage impediments. Non-marital cohabitation is de facto relationship in Serbia, so it is not possible to register it. Consequently, there can be difficulties in proving the existence of non-marital cohabitation in the court practice. What are marriage impediments? Marriage impediments are existing marriage, underage, kinship, adoption relationship, affinity, inability to reason, free will, and guardianship. If non-marital cohabitation does not meet these requirements, at the moment of its establishment, the court should apply civil law norms to the acquisition of property. However, if impediments subsequently cease, marital cohabitation becomes lawful. And another form of partnership is same-sex union. Serbia is one of European countries that today does not have any laws on same-sex union. One may be of in our region, one of the countries in the region. Also, Bosnia and Herzegovina does not have a law of same-sex union. But other countries of ex-Yugoslavia, for example, Slovenia, Croatia, do have this kind of legislation. In Serbia, for now, we have the draft law from 2021, which regulates two types of same-sex union. First is registered same-sex union, and second is de facto same-sex union. So we can say that parallelism of concepts exists. Registered same-sex union has legal effects only if there are no impediments for its conclusion. De facto same-sex union has legal effects only if there are no impediments for its conclusion and if lasts for 3 years. There are small differences between impediments for marriage conclusion and for the conclusion of the same-sex union. Difference exists in connection with impediment of guardianship, as guardianship is marriage impediment, but is not stipulated as impediment for conclusion on the same-sex union. The possible explanation why guardianship is not one of the impediments for conclusion of the same-sex union is in the fact that same-sex union is not possible to conclude before persons are 18 years of age, so guardianship cannot exist between two persons who want to conclude same-sex union. This is possible for marriage because marriage might be concluded if person is 16 years of age and gets court permission. The person who is unable to reason cannot conclude same-sex unions or guardianship in this situation is not relevant. How a same-sex union is concluded? Same-sex union is concluded by affirmative and uniform statements in order to realize the cohabitation given before the registrar. Same-sex union is to be concluded before the registrar in a solemn manner and in a room specially designated for this purpose. The registrar may exceptionally allow for a same-sex union to be concluded in another venue if there are justified reasons for doing so. The future partners, two witnesses, and the registrar are to be present at the conclusion of same-sex union. The conclusion is the same as the conclusion of marriage, one might say. How is it cancelled? Same-sex union can be cancelled in the court proceedings or exceptionally by registrar. This is break by agreement. Each partner has the right to court cancellation or break of same-sex union by action or by agreement. If the relations are seriously and permanently disturbed, or if the same-sex union cannot be realized, the termination is by an action. If it is on agreement, the agreement of the partners must include a written agreement on the division of community property. These provisions are the same as provisions for divorce. It is stipulated in the draft that exceptionally a same-sex union can be cancelled by giving concessional statements of will to the registrar. This is not an option for divorce for now in Serbia. So this is one difference in cancellation between marriage and same-sex union. What are legal effects of same-sex union? Legal effects of same-sex union are very similar to legal effects of marriage. Personal effects are: same-sex partners consensually and jointly decide on all important matters for their life together, have right to protection on privacy of their family life, and right to mutual cooperation, have a duty to help each other and to care and give help in the case of illness. Upon concluding a same-sex union, partners may agree on their surnames. Another family law effect concerns property rights. Partners might have separate and community property, identically to spouses and heterosexual partners in non-marital cohabitation. The contract on property is available to same-sex partners during or before conclusion of same-sex union. In my opinion, it might be better solution for Serbian contemporary situation to having in mind social circumstances and accepted views in the population to start with the regulation of same-sex union as an institution which differs from marriage. For instance, to abandon the condition for witnesses to be present, to abandon solemn form and possibility to register partnership outside the registrar's office. For the dissolution of the same-sex union, the proposal would be to stipulate registrar as only competent organ, not the court, in the all situation, not only exceptionally, and that will be the difference between marriage and same-sex union. Then to stipulate two ways of dissolution, by mutual agreement and by unilateral demand, without stipulation of the grounds as for the divorce. The jurisdiction to decide on legal effects of same-sex union should be the court as the same as for divorce. These changes would make considerable differences between same-sex union and marriage. In a way, how is same-sex union regulated by draft law today? The only difference between same-sex union and marriage is, in fact, in the term which is used. But in fact, same-sex union is equal as marriage in concluding ceremony, termination, and legal effects. accepts adoption and artificial reproductive technologies. Same-sex union is, it might be said, is parallel to marriage, and de facto same-sex union is parallel to non-marital cohabitation. And at the end, I would like to stress that family relations are concerned, is easier for community to accept new institutions to take step-by-step approach. The difference in social circumstances is the reason why European Court for Human Rights accepts wide margin of appreciation when make decisions in family law issues. This aspect seems to be acceptable to European and international law and institutions. To start with regulation of the same-sex union with the considerable differences to marriage, but to protect personal and property rights of the same-sex partners. I suppose this would also be the way to avoid constitutional considerations, as it would be clear the same-sex union is not marriage. Thank you for your attention and to giving me the opportunity to finish my presentation.